Hey, good afternoon, everyone. On behalf of the American Red Cross and our International Humanitarian Law program, I want to thank all of you for taking time out of your Thursday to join us here today. Uh, we have a really interesting look here today at the military justice system in the United States and how it handles IHL accountability. And this isn't going to be a typical lecture where I just talk at you about legal concepts in a vacuum. We're actually going to use a real life case as a case study to help illustrate how the military justice system works and how it handles allegations of IHL, International Humanitarian Law, otherwise known as the law of armed conflict or the law of war, how it handles allegations of violations of that body of law. So you're actually going to get to see this play out, or how it played out in a real life case. I'm Thomas Harper. I serve as the senior legal advisor in IHL for the American Red Cross, and I help lead our International Humanitarian Law program. We carry out the mandate under the Geneva Conventions of educating the American public about IHL. This is a dream job for me, and the chance to talk on a topic like this is a dream opportunity as well. Not just because I really enjoy the laws of war and talking to folks about them, but I also have a pretty deep background in uniform as well. The UCMJ, the military justice system, has been an integral part of my professional life. I've been a judge advocate for more than 10 years. I've been in uniform in the Army more than 20 years, having originally enlisted out of high school. But in my capacity as an Army JAG officer, which I still do to this day in the Army Reserves, a lot of my time has been dedicated to military justice positions. I've been a prosecutor on active duty. I've been a defense counsel on active duty. I've tried courts martial. I've been in the exact sort of scenarios that we're going to talk about today at all points that this system, that our military justice system operates, from investigation to charging decisions to courts martial, on both sides of the aisle. And I still to this day serve as a military defense counsel, albeit at a little more senior level in my reserve capacity, out of the 16th Legal Operations Detachment in New York. So that's going to be the backdrop. That's going to be sort of the dual-hatted nature of this. But my purpose here is to talk to you from my position as a Red Cross senior legal advisor. So we're here to educate. We're not here to make final calls or judgments on the system. I'm here to pull the curtain back, leverage my experience, and help educate all of you about how this system works and its intersection with allegations of IHL violations. So with that, frequently we don't go very long without stories in the news or questions about what happens when U.S. service members are accused of violating IHL, are accused of war crimes. Certainly our military has been very active in places like Syria, Afghanistan, and Iraq, and more for the last 20 plus years. And so stories like this are uncommon, but they do come up time to time. And I say uncommon because the vast majority of U.S. service members complete their deployments, complete their missions in areas like those. And there are no such allegations. They do their job professionally, like many of the professional militaries in the world, and this isn't an issue. But from time to time, these allegations arise, and they've arisen recently. These three cases here, Chief Edward Gallagher, who's a Navy SEAL or a former Navy SEAL, Major Matthew Goldstein, who's a former Green Beret, a Special Forces soldier in the U.S. Army, and Lieutenant Clint Lawrence, a former paratrooper with the 82nd Airborne. All three of these individuals had their cases sort of play out in the public eye, or some aspect of their case play out in the public eye, caught headlines. And so these cases do catch the attention of the American public. They are serious. And so it begs the question, how does the U.S. justice system handle cases like these when these serious allegations arise? Today, for our purposes, we're going to focus on a specific case. And I selected United States versus Gibbs, which is a 2011 case. I'll explain more about the case itself. This is one of several trials that occurred with relation to some serious allegations of IHL violations. And I selected this case in particular, the Gibbs case, because the appeals have run, the appeals are completed, the case is done. There's no pending aspect to this case, to my knowledge. And so with that, we're not going to talk about a case that's actively before any military court or might stir up any controversy. This one is done, it's completed, and so it serves as a good and more recent case study for us to examine this. So with that, I'm gonna play a clip here that's relevant to this case. There will be audio, so modulate your audio. If you have your speakers turned way up, just check that. There's also going to be, we're going to deal with some graphic imagery. The trailer itself doesn't have a ton of stuff, but I do offer that warning in case you have any younger folks watching or anything like that. Just be warned that this does deal with IHL type violations and violence.
Being a part of something like this is a tremendous thing. I'm proud of you.
Morning, Sergeant.
Gentlemen, whoever's making these has to answer for the deaths of 24 American soldiers in the past 12 months. And every day we don't find them is another day an American soldier could come home in pieces. Who wants to make a difference?
Hey, Dad. Things are really taking off for me.
How do you like it, Coach?
Bloody.
Caveman. So, gentlemen, what's the play?
Relationship building, Sergeant.
Is you serious? Now, who's ready to have some fun?
I just keep thinking about that kid that we killed today.
What, do you think it's wrong?
Yeah, I do.
You kill one of theirs, you save 10 of ours. You're telling me that's not right? You think that man was innocent?
He didn't deserve to die.
They're cooperators.
Andrew, tell me what's going on.
You know that anything that happens out here stays in the family.
Hey, Briggsy, do me a favor. Go get the targets. You think we're gonna shoot you or something?
You're trying to do what you think is right. The problem is, you don't even know what right means.
Leave me alone.
You are alone.
Andrew?
I don't know what to do anymore.
Do I do the right thing and put myself in danger?
Or do I just shut up and deal with it?
You give me your loyalty, and I guarantee that each and every one of you will have a chance to be a warrior. To actually be a part of history. Ready on 3. 3, 2, 1.
Okay, now that's a movie trailer. It's based in part on a 2013 documentary about this case, but that trailer is fictionalized. The characters, some of the scenarios, and the names are all fictionalized. But that provides you with a little bit of flavor about what we're talking about. The case centers on a unit called the 5th Stryker Brigade Combat Team. So this is a unit that no longer exists. They reflagged, meaning they sort of merged into a different unit, which now today is 2nd Brigade, 2nd Infantry Division. This unit was out of Joint Base Lewis McChord, or Fort Lewis, as the Army used to call it. And this is just south of Tacoma, Washington, within that red shaded area on the map there. So this Stryker Brigade Combat Team, they operate primarily using these vehicles. You saw them in the trailer there. This is the Stryker Infantry Carrier Vehicle. You've probably heard about Strykers in the news with regard to the U.S. providing some of these to Ukraine. But this is a sort of a vehicle that carries infantry around. It can be modified in a variety of ways. This is what they deployed with to Afghanistan. And we're going to focus in on a subset of that unit. The entire unit wasn't accused of or involved in these crimes. It was with a select group of soldiers within 3rd Platoon of Alpha Troops. So this is a platoon is just a smaller size unit within that brigade combat team. And you have 4 individual soldiers that we're going to focus on, really a 5th who I'll mention in a second: Morlock, Holmes, Wagner, and Winfield. Some of those were reflected or portrayed by actors in that trailer. They're members of this platoon and squad mates, and they're led by Staff Sergeant Calvin Gibbs. Now, during this deployment, they're deployed to Maiwand District, which is in Kandahar Province. They're at a place called Forward Operating Base Ramrod. So it's a small base, kind of far-flung, and they're conducting a variety of operations during the time period of 2009, and this is in the context of Operation Enduring Freedom. Now, Sergeant Gibbs wasn't with the unit when it deployed. The unit deployed to Afghanistan. It suffered some losses in combat, and Sergeant Gibbs actually came in to replace another squad leader who was injured. Gibbs came in with a veritable track record. He had combat experience. He had deployed to Iraq before. That stood in stark contrast to some of the members in the unit, younger soldiers who this was their very first deployment. They looked up to Sergeant Gibbs. He had sort of a reputation as a warfighter, and as an infantryman leading other infantrymen. They looked to him as sort of a combat leader, somebody who had been tested in that crucible. What ended up happening is that Sergeant Gibbs and those individuals I mentioned before ended up perpetuating a number of murders of civilians there in Afghanistan. There's a photo that one of them took along the way, and it was a piece of evidence that was really integral as part of the trial. But they dubbed themselves the Kill Team, and although the eventual charges against them we'll talk about encompass a subset of this, they're tied to the deaths for the murders of 4 Afghan civilians, including a teenage boy, and a man who, according to the investigation, according to local reports, may have had some mental disabilities, and they sort of infamously took body parts as trophies, just really awful trophies from their victims, things like fingers or pieces of other pieces of the body. They dubbed themselves the Kill Team, and so that sort of sets the table. That's it. It doesn't get much worse than that in terms of allegations. I'll talk to you a little bit about how they perpetuated those crimes as we get a little deeper into the presentation, but that sets the table. So I want you to put yourselves in the shoes of a military commander, and I'm going to put a question, a multiple choice question to you, the audience. You can feel free to enter your answer in the chat, but you don't have to. This is completely anonymous. You can just think about your answer, but it'll sort of give us a flavor for the rest of this discussion. So as a military commander, you're going to pick what you can legally do here. Or in a general criminal situation. So can you launch a formal investigation into criminal misconduct within your unit? If you heard of this incident with the Kill Team, could you start an investigation in some way? Could you execute a full search of unit barracks, or maybe of that forward operating base, Ramrod there? Search through the soldiers' personal areas with drug sniffing dogs and no search warrant? Could you order a soldier into confinement? By that I mean jail, before any criminal trial has occurred? Or could you make a decision on whether a certain alleged crime is going to be prosecuted for a crime that's allegedly committed within your unit? Think about your answer there, and sort of the power that you might have as commander. Is it none of these? Is it some of them? Actually, the answer is all of them to some degree. Now, obviously, I'm painting with a really broad brush here. There's subtlety and nuance to each of these and the ins and outs. But the bottom line that I want to send home here is that while the UCMJ, the Uniform Code of Military Justice, which is the criminal code that we'll talk about here today, that governs the criminal conduct of U.S. service members, a lot of authority and a lot of authority is vested in military commanders. They are entrusted to make a wide range of decisions, and they're empowered to utilize their judgment to make a wide range of decisions with regard to criminal cases. That doesn't exactly match up to the civilian system that many of us are familiar with. If you're living in a city or a town, you probably have a prosecutor, an elected district attorney who has an entire staff, other attorneys, other prosecutors that weigh in. You probably have a police force, both at the federal, maybe state level. You have federal prosecutors who are active in doing some of these things that are listed here. But a lot of that power is centralized in military commanders within that system. They're backed by judge advocates, and we'll talk about that, the folks that give them their legal advice. But a lot is invested or vested with those commanders. So that begs the question, what do you do with an allegation with a soldier like Staff Sergeant Gibbs if allegations like this come down? And what do you do when it comes to criminal accountability? Where do you even start with a case like this? Well, this occurred in Afghanistan. We saw that in Maiwan District, Kandahar Province. Afghanistan is a country, it's a sovereign nation. At the time, it's ruled by an elected government, and they have an entire legal code. They have a criminal code in Afghanistan that includes coverage of things like murder and the like. So there is a criminal code there locally that could theoretically account for crimes like this. Certainly Afghanistan had criminal investigators. This happened in their country. So would Afghan law be applicable here? Could it be used with Sergeant Gibbs? Well, no. There's a key document there, and this is something that U.S. forces almost always operate under when we're operating in another country. And it's a document, a legal agreement known as a Status of Forces Agreement, or a SOFA. Now, the SOFA in Afghanistan dates back to 2003, and it was in operation in 2009 when these crimes occurred. And I'll say crimes, not alleged crimes, because what we're talking about, they were found guilty of, they were convicted of. There's no need to use that qualifier alleged with regard to this case. But what the SOFA puts forth or set forth with regard to U.S. service members is that the government of Afghanistan agreed that the United States would have sole and total jurisdiction over criminal offenses with regard to U.S. citizens, U.S. service members, etc. So there's a key aspect of that SOFA that blocked out the ability of the Afghan government to prosecute any of these soldiers, Sergeant Gibbs or his squad mates, for this sort of thing. It was a legal block to Afghan authorities being able to pursue anything. And that's not uncommon for U.S. forces. We had a SOFA in Iraq during the Iraq War that had similar provisions, and in fact, the question of immunity for U.S. service members under Iraqi law was a key sticking point back in 2011, or the 2010-2011 timeframe, when the SOFA came up for renewal, and there was a decision about whether U.S. service members would stay on. Obviously, there's political ramifications and all of that we're not going to go into, but the bottom line is that Afghan law is boxed out here as a means of criminal accountability. Now, what about the International Criminal Court? Now, the ICC, which was set up by the Rome Statute, has been in existence since 2002. You have 123 countries who are state parties to this treaty, to the Rome Statute, and this is the international court with jurisdiction to try those accused of war crimes. It is the permanent international court with jurisdiction over allegations just like these, IHL violations. Now, and the Rome Statute provides that legal framework of how that court operates, its reach, etc. Now, a key difference here is that while Afghanistan has acceded to the Rome Statute, they are considered a state party to the ICC. The United States is not. the U.S. played a key role in helping bring the Rome Statute and the International Criminal Court about, but we have never acceded it or joined as a state party to that statute, to that court. And at the time, in 2009, when these crimes occurred, the U.S. had a fairly hostile position toward the Rome Statute. We had under the administration around that time, or the administration that had just changed hands, the immediate prior administration, we had the United States had sort of cast off all of its obligations under the Rome Statute, basically kept it at arm's reach and said, we have no involvement. This statute, the ICC, has no reach or ability to reach U.S. service members, and we're not going to cooperate in any way with ICC investigations. And around this time, circa 2007, you actually did have an investigation that was opened by the ICC prosecutor, the chief prosecutor, into alleged war crimes dating back to 2003 in Afghanistan. Now, this was wide-ranging. It didn't just involve U.S. citizens and allegations against them. It involved Taliban members. It was fairly comprehensive. 10 years later, in 2017, the prosecutor sought to move that case forward formally into the pretrial chambers. And I won't go down the rabbit hole in terms of ICC operation, but suffice it to say that the prosecutor sought to advance that case. They had the ability to conduct that investigation in spite of the U.S. not being a member of the Rome Statute, because Afghanistan is a state party to the Rome Statute. So it seems like perhaps this was going to set the tone or set conditions for trial of cases like Sergeant Gibbs, or accountability in the ICC for these cases. Well, in 2019, the decision was rendered by the judges that that request by the prosecutor was rejected. And there's a lot that's baked into that, but the phrase that they used was that the investigation was not or would not be in the interest of justice. And so, effectively part of that baked in was the likelihood that the United States just would not cooperate with at least its own citizens, certainly not U.S. service members, and exposing them to potential accountability under the Rome Statute in the ICC. So I have really simplified that in a nutshell, but what the effect was, the practical effect, is that the ICC is not the proper venue, or not a viable venue for addressing a case like Sergeant Gibbs either. So you can't do Afghan law, you're boxed out from the ICC. And so where does that leave us? Well, we come back to the Uniform Code of Military Justice, that code that governs the conduct of U.S. service members. UCMJ, courts-martial and the ability to hold soldiers accountable dates back as long as the United States military has existed in some form or another. But the UCMJ, as we know it today, stood up in 1951, and it's comprised of three main sort of pillars. You have your rules for court-martial that dictate how courts-martial are set up, how they're run. Think of them as sort of a body, a comprehensive body of procedural rules, starting from sort of the earliest point in a case and reaching all the way into the appeals process. You have your military rules for evidence. These are a rough mirror, not an exact mirror, but a rough mirror of the federal rules of evidence. These are the rules for how a trial, how a court-martial is actually conducted. And then finally, there are four components. I left one out. You have your non-judicial punishment, which we won't go into today. So that's a body. It's an option for commanders to handle certain offenses. And then lastly, and most importantly here, you have the more than 60 punitive articles. So those are effectively the criminal statutes, if you will, of the UCMJ. And that's what we're going to focus on as we take his case forward. Jurisdiction is a question here. Jurisdiction is always, this is like a legal term for which you can spend you end up spending an entire year of your law school sort of studying about. in a class like civil procedure. Jurisdiction is the ability of a court to account or to handle, to take accountability for a particular crime. Jurisdiction is critical when you talk about whether a court is empowered to handle a crime like the ones that Sergeant Gibbs committed. This is a tricky case because these crimes were committed in a province in a country that's over 7,000 miles away from the United States. So how does the UCMJ, a body of law that's governing soldiers who are typically based in the United States and a few places abroad, how does it handle this sort of hurdle? How does it reach crimes committed in a war zone like Afghanistan? Well, that's because the UCMJ has global jurisdiction. So it covers offenses committed or allegedly committed by US service members worldwide, and at least in the case of active duty soldiers, around the clock. So this is the jurisdictional blanket, if you will, covers that entire globe, and it would extend to Afghanistan. And that was the basis for using the UCMJ in Sergeant Gibbs' case. So I want you to put yourselves back in the shoes of a military commander. I've just put the rank of colonel here, but military commanders come in a wide variety of ranks and a wide variety of echelons. But I want you to put yourselves in the shoes of a commander. So you have jurisdiction. So this crime occurred a ways away in a combat zone. We're okay to use the UCMJ. What's a starting point to actually uncover facts about the case, to build a case that might later see a trial? How do you go about that, and what power does a commander have? Well, the commander has a variety of tools in their kit to handle cases like this. There's a wide range of law enforcement investigations, both military law enforcement investigations, as we'll talk about in a second. Oftentimes, civilian criminal agencies, civilian law enforcement agencies are involved in cases involving US service members. The FBI, state bureaus of investigation, local and state police, you name it, law enforcement has the full ability to investigate in these instances. Commanders also have a couple sets of they're termed administrative investigations, and informal inquiry is sort of an extension of that. And that's the ability to task a military officer, a military member, with the business of investigating certain circumstances, certain allegations. Now, with a case like Sergeant Gibbs, we're not going to be dealing in the areas of administrative investigation. There's sort of some wickets that you navigate through, and when it comes to serious crimes or allegations of serious crimes, really you're going to be honing in on law enforcement investigations. You wouldn't have a murder allegation come up and a commander decide to field an informal inquiry. That's where your judge advocates are going to come in and steer the commander in the right direction, that law enforcement, either civilian or military, are going to be involved in this sort of thing. The United States Army, like other branches of the military, has its own corps of military investigators. Now, these come in some different flavors. We'll focus on the Criminal Investigation Division of the U.S. Army, CID, because this Sergeant Gibbs case is an Army case. CID are your military investigators. Their whole job is to investigate crimes, serious crimes committed by US soldiers. And CID is active. They deploy and they conduct investigations in the field. So an Army CID investigator, these are a mix of soldiers and civilians operating in this role. But the Army has a contingent of trained investigators that would go out and collect evidence. They'd conduct interviews, they'd do forensics. They have all the sort of tools and training of a civilian law enforcement agency, something like the FBI or a police department. They have that at their disposal, and they function in both a garrison or a role back in the States or on a US military base, and in a deployed environment as well. So in the context of Sergeant Gibbs' case, you're going to have a criminal investigation, and because you're forward deployed, you probably don't have access to investigators like you do back in the States. You can't call up the FBI, or there's certainly not state police that are there that are going to be having a role. It's going to fall to CID. Well, then the question becomes, so you've collected your evidence. How does the UCMJ handle IHL violations? Well, we talked about those punitive articles, those 60 plus criminal statutes that really identify criminal conduct, specific actions that are considered criminal conduct within the military. You have crimes against property that are codified there. This isn't a full list, but things like larceny, fraud, robbery, that sort of thing. The UCMJ punitive articles also have a number of crimes against the person, assault, murder, battery, rape, and sexual assault, those sort of things. You also have a couple unique areas of one large unique area of the UCMJ, and that's in the criminalization of certain military-centric actions, things that really don't have a mirror on the civilian side. So things like being drunk on duty or AWOL, failure to obey an order. These are things that on the civilian side, if you don't show up for work, if you show up to work drunk, or you refuse to do what your boss is telling you, you might get fired, you might get reprimanded or disciplined in your job, but there's usually not going to be a criminal offense that follows. I like to call these are the Pauly Shore offenses. If you've seen In the Army Now, this movie is probably older than a lot of the people that I know these days. But think of these as sort of your In the Army Now type offenses. But there's a subset of those military centric offenses that really hone in on conduct that is that takes place in combat zones. So things that really don't have the ability to be committed in most circumstances back at your home station. So things like misbehavior before the enemy, aiding the enemy, misconduct as a prisoner, and that means a U.S. service member who is a prisoner of war, that sort of thing, or compelling surrender of your unit. Now, there are circumstances you could theoretically aid the enemy from home station back at Joint Base Lewis McChord in some fashion, but largely these are crimes that really attach to conduct of soldiers in combat zones. And so it begs the question whether those military-centric offenses in the UCMJ, whether those 60 plus punitive articles codify any violations of IHL, of the Geneva Conventions, for example. So let's take a look at that. Now, what we're talking about here in the case of Sergeant Gibbs, the business of killing civilians and treatment of the dead. And by treatment of the dead, I'm specifically talking about that taking of body parts as trophies. We'll focus on those two crimes. We'll see in a second here that more crimes were encompassed in this case, but certainly those two crimes are covered under IHL. We're talking about the Afghanistan conflict, so what we're talking about here is a non-international armed conflict. So we're going to look to Common Article 3 and Additional Protocol 2 as the portions of IHL that really pertain to a non-international armed conflict. We'll first take a look at Common Article 3. Does it have anything to say about the murder of civilians? Well, absolutely. So under Common Article 3, murder of persons, right, of non-combatants is outlawed under Common Article 3. So in a non-international armed conflict like this, it is a grave breach of the Geneva Conventions. It is a war crime to murder. Okay. What about your treatment of the dead? Well, let's look to Additional Protocol 2. So a portion of it talks about the entitlement to dignity, to someone's person and honor, and it prohibits outrages upon personal dignity, and in particular, humiliating and degrading treatment. Now, this has been interpreted to cover the dead. So this encompasses both protections for the living and the dead. And certainly dismembering portions of a body to take pieces as a trophy, that's an outrage. That's an outrage upon your personal dignity. That is not respect for that person, even though they're deceased. And so that would be a violation. That would constitute a breach of the Geneva Conventions, a war crime, if you will. So we have coverage of the central acts in this case, both the murder and the treatment of the dead after they're killed under IHL. Is that reflected in the UCMJ? Well, no, you're not going to see, not strictly at least, you're not going to see any article, any provision of the UCM or of the Geneva Conventions, of Additional Protocol 2, of Common Article 3, carried forward verbatim in the UCMJ. There is no punitive article in the UCMJ that cites to any article of the Geneva Conventions, that cites to either of the areas that we're talking about here today. It is non-existent in that document. What does that mean for Staff Sergeant Gibbs? If the UCMJ doesn't specifically codify the certain war crimes as crimes, as punitive articles, how does the U.S. military possibly ensure that a soldier like Sergeant Gibbs is held to account for his actions? In Sergeant Gibbs' case, you saw it sort of portrayed a little bit in that trailer, but in his case, he and the other soldiers from that kill team openly discussed how easy it would be to kill civilians in their area of operations. They had some twisted motives in discussing this sort of thing that really don't bear on our conversation here today. But this was an open plan that they had. And the way that they accomplished these crimes, or attempted to cover them up, was staging them to look like combat scenarios. So you saw that quick scene in the trailer in which an AK-47 is placed next to a dead body and some sand is sprinkled over it. You also saw use of hand grenades. What the soldiers did there with Sergeant Gibbs in the lead was to take certain confiscated weapons, AK-47s, of which they had a few, and they would place them next to the bodies. They would place, say, a grenade or something like that next to these bodies. And following these engagements, following these murders, their story was that they had been engaged by these civilians and they responded to defend themselves. And in their words, it was necessary to kill these individuals because they were attacking. They were taking direct part in hostilities. They were aiming or shooting or using a grenade against US soldiers. So in other words, they knew what the rules of war were. They knew what their rules of engagement were in this particular scenario. And they attempted to do an end around to justify their actions, to make their actions lawful. Well, consider this phrase here. So any person who without justification or excuse unlawfully kills a human being who he has a premeditated design to kill, and focus on that phrase right there, human being. They're guilty of murder, and that's under Article 118 of the UCMJ, probably one of the most serious, if not the most serious, of the punitive articles. And what I highlight there, why I highlighted human being in green, is because it doesn't talk about in specific terms. It doesn't limit itself to US citizens. It doesn't limit it to a specific geographical area. So say murders committed in the continental United States or on a US military base. It is very broad in scope and encompasses the broadest definition of, in terms of the victim of a murder, possible. That sets us up to look at the actual charge sheet. So this is a charging document from the case. It's been redacted, but this is from Specialist Jeremy Morlock, who was one of those individuals on the kill team that I pictured earlier. The charge sheet is the formal document that outlines and puts a soldier on notice, or a service member on notice, of the allegations against them. So this is the actual document in the case. You can see down there in section 3 toward the bottom, referral. This officer who signed it is the one formally making the allegations. They are what's called preferring these charges. And you see them laid out there. You see Morlock is the one accused, and you're going to see these charges laid out both in charges and in specifications. So a charge is going to allege a violation of one of those punitive articles. So there you see Article 81, which deals with conspiracy. So the specifications there are specific instances of conduct that are being charged. Specific instances that are different from each other, obviously. So different acts that are being charged. So he has two specifications there of conspiring with different individuals for different objects of the conspiracy. So these are two different conspiracies. And right there, dead middle on charge 2 is the violation of Article 118. So the specs 1, 2, and 3 relate to 3 murders, and they, as you can read right there, they pertain to Afghan civilians, Afghan citizens. So the UCMJ doesn't limit prosecutors, doesn't limit investigators to only concerning themselves with some particular small subset of crimes. But what you also see is there's no mention of war crime. There's no mention of these being in violation of the Geneva Conventions or the law of war, the law of armed conflict. These are murders. It is treating these actions as exactly what they are, which is murder. And now you have down there at the bottom, if you can see it, at least a portion of one of the charges dealing with their actions after the killings. Here, Article 92 is the violation of a direct order, and it talks about the photography of casualties. That would have been a violation of a written rule, a directive from their commander, some higher echelon that says, hey, U.S. service members, you are not, with a possible exception, certain exceptions, to take photographs of deceased individuals. And by actually taking pictures of those, I showed that gruesome picture toward the beginning. That picture in itself, the act of taking that photo, is a violation of a direct order and therefore a violation of the UCMJ that can be prosecuted. So I show you this charge sheet because this is how, and this is Morlock's, not Gibbs, but this is how the Army got at charging these underlying acts. So they're not using some mechanism to bring in some provision of the Geneva Conventions, because the UCMJ is equipped to deal with situations like this with its existing punitive articles. So he's been investigated, he's been charged, and with a crime like this, certainly a murder is going to be fit for some sort of trial. So what does that look like in the military system? A military trial is a court-martial. You've probably heard that term thrown around in sort of popular culture and all sorts of ways. But a court-martial is just a military trial. They come in 3 different flavors primarily: a summary court-martial, which is the lowest level; a special court-martial, think of that as sort of the equivalent of a misdemeanor trial at the federal level; or a general court-martial. This is a full-on federal trial, and is used for a wide range of offenses. Generally speaking, we're talking about serious offenses that end up at GCMs, at general courts-martial. And so with the crime of murder, with these sort of allegations, your only stop is a general court-martial to handle these kind of offenses. That is the venue for which we're going to accuse these soldiers and pursue accountability for their crimes. Now, this is the part where I pull back the curtain a little bit, because court-martial is one of those terms that is, for a lot of folks that have no experience in the military or with the military justice system, sort of shrouded in secrecy. I think thanks to movies and TV shows, it sometimes gives you the knee-jerk reaction or imagery of some dark, shadowy room and military members that are in secret handing down judgments with who knows what rules in place. And the reality is quite the opposite. These are very formal proceedings. These are federal trials, in essence, that are bounded by rules and that are bounded by a very, very strict structure. So a court-martial is no different, at least in concept, than a normal criminal trial, say in a U.S. district court at the federal level. So it's headed by a military judge. So a military judge would be a senior ranking officer who is an attorney. Military judges come exclusively from in the case of the Army's Judge Advocate General's Corps. These are folks with tremendous amounts of experience, legal training. They have, in most cases, been criminal litigators themselves. They've been prosecutors. They've been defense attorneys. They have a lot under their belt, so to speak, when they take the bench. Their job is to run the show at the court-martial, and the accused, so someone like Sergeant Gibbs, has the option in most cases of deciding whether he is going to be tried or she is going to be tried by the military judge alone, so what we know as a bench trial, or with a panel of members. That's what we call a military jury. But the military judge at the core is going to be that quarterback for the trial, to make sure the rules are abided by, to make judgments and decisions on objections from counsel, to control the flow of evidence that comes in, and to ensure that those rules for court-martial and the rules for the military rules of evidence are abided by, to ensure that the accused's rights are respected throughout the process. You're going to have prosecution and defense counsel, just like you do in any civilian trial. The default is that on both sides of the aisle, both the prosecution and the defense are military attorneys. In a court-martial, your prosecutors are always going to be military attorneys. These are licensed attorneys that with varying levels of experience and trial experience. And for a case like Sergeant Gibbs, you're almost certainly going to have more experienced prosecutors that are tasked to take a case like this. This is going to be a case that the Army entrusts to its very experienced litigators, understanding the complexities and the seriousness of offenses like this. So usually that's someone of more senior rank. They've been in the JAG Corps for a number of years, and they also, similar to the judge, have that sort of experience under their belt. Similarly, the accused soldier, somebody like Sergeant Gibbs, is going to have automatically the right to defense counsel. As a default, they're going to have access to a military defense counsel, maybe two, like myself in my reserve capacity. Defense counsel exists in both the active duty and the reserve component, the reserve and Army National Guard. And we're litigators just like those prosecutors. We have varying levels of experience, and for a case like this of its seriousness, a murder case, you're usually going to find those more experienced defense counsel, those more senior ranking defense counsel assigned to somebody like Sergeant Gibbs. They also have the ability to, at their own expense, hire a civilian defense counsel should they choose to do that. And so sometimes in cases you'll see a mixed team of both civilians and military defense counsel, or just civilian defense counsel. But the bottom line is that they are fully protected with representation of counsel throughout that process. Now, the military jury, the panel, as we call it, is unique because of its composition. These are military members, so they're drawn from that installation, and these are usually senior ranking soldiers, none of whom really have a connection to the accused soldier. That's taken care of and watched out for by counsel during the jury selection process. But in a general court-martial, you're going to start with 12 members. Now, the rules that govern courts-martial have changed in recent years, but in 2009, you could shave that starting 12 down to below 8 members. So during the process of jury selection, both sides get to challenge those military members. They're not forced to accept those that are on the panel without the ability to question. So they get to ask questions of those panel members. and they get to mount challenges, just like civilians do during civilian criminal trials. The key difference in a military trial is that a unanimous verdict is not required. That's something that remains contentious, that remains under litigation, but unlike the civilian system, where there's a Sixth Amendment right or a protection that ensures that at least in civilian trials, you have to have a unanimous verdict, the military system in most cases requires just a 2/3 verdict, meaning that those jury members, those panel members, don't have to come to a unanimous verdict to find you guilty. And obviously the math on how many constitute 2/3 changes as you whittle down that number from 12. And that's certainly part of the calculus for both sides during the jury selection process. But these are going to be a cross section of individuals from the installation. Interestingly, that pool of panel members is selected usually by a senior commanding officer on the installation, what's known as the General Court-Martial Convening Authority. That individual picks the pool. It's not a random jury pool selection like you see in the civilian world. And you whittle it down from there. But in a contested trial with members, that means a military jury is going to be sitting as the fact finder for the case. Now, upon conviction, you immediately enter into a sentencing phase. Usually, there's not the sort of delay in sentencing that you see in a federal criminal trial, where you have the finding of guilt and then probably a bifurcated separate sentencing hearing that happens at some point down the road, maybe a few months later. You usually roll straight into sentencing, and so that accused has to come prepared to present a sentencing case in the event that he or she is convicted. Both sides, both the government and the defense, get to put on evidence that feeds into their sentencing argument. And in the case of the government, they're going to be presenting any factors that they believe aggravating that justify a particular sentence or a higher sentence. And the defense is going to put on matters in extenuation and mitigation, so reasons why a lesser sentence is in order. And punishment includes an entire range of options, and you know, most specifically or most pertinent to this case, punishment includes jail time, confinement, as we call it, and one of the central confinement facilities in the U.S. military. Pictured here, it's at Fort Leavenworth, and that's the U.S. disciplinary barracks, where a number of service members from across the branches who've been convicted are housed and serve their punishments. There's an appeals process as well. I won't get into that here today, but there is a sort of baked-in appellate process for those convicted of crimes that the military has as well. Convicted soldiers have a pretty robust set of appellate rights following conviction there. So in this case, I'll go through the punishments here. Holmes, Specialist Holmes was sentenced to life in prison. Winfield, who was one that came forward with that helped sort of break the case open, he ultimately served a few less years there. Specialist Wagner here, the Army dismissed his charges without much explanation, just said it was in the interest of justice. Sometimes you see that if a decision is made to not prosecute the case for a variety of factors, weight of the evidence, how likely it is that they'll achieve success. Sometimes you can have a dismissal that's connected to a plea deal. So somebody agrees to testify, and part of that agreement is a particular outcome or range of outcomes in the case. His charges were dismissed, and you have Morlock there with a very heavy sentence as well. Morlock actually testified under the terms of a plea deal, so he was spared life, although he did get a lengthy sentence of confinement. He came in and testified against Sergeant Gibbs. That was a central pillar of the government's case against Gibbs, and Gibbs was sentenced to life confinement. So I'll pause just real quick. We're close to the hour mark, but just to see, Christian, if we have any questions that have come in that I might be able to answer, and then I'll wrap up in just a couple minutes here by talking about how you can get involved with the Red Cross IHL program as a volunteer.
The first question is just for clarifications. It says Holmes was released, right?
That could have happened. Yeah, I think he might be out by now, but I'm not sure.
Another question was the development of the UCMJ a follow-up to the Nuremberg trials?
There might so I'm not a UCMJ expert and history expert. I think there might be some connection point there, but I think the development of the code happened independent. I think it was an inevitability, regardless of what happened, what form of justice happened following World War II. There was sort of a patchwork of accountability measures that predated the UCMJ, and it really filled a much needed void.
Just to add on to that, yeah, the Articles of War was given to the Navy and Army also after the 20th century, before the end of the World War I. How often do military IHL trials happen? Are they always made public knowledge when they're happening?
So these cases, sort of just like federal trials, by default, they are public. They're open. Courts martial are open to the public unless for some reason the court is closed to the public. Usually by a similar set of mechanisms to a federal court closing down. Does every single IHL type trial of varying degrees catch public attention? No, and you have to understand that there's a wide range of conduct that could be ensnared in something as simple as theft, theft of civilian property, unlawful taking of war trophies or war booty. Those aren't things that necessarily would catch the attention of CNN or national news outlets, but nonetheless, soldiers are still held to account. I can't speak to specific numbers about courts martial and number of IHL violations. They're thankfully infrequent, and that's less to do with appetite to prosecute and more to do with the infrequent nature of these sort of allegations against U.S. service members. And with my Army hat on, that's a credit to the professional nature, generally speaking, in which U.S. service members operate.
There is some information in the chat regarding jurisdiction over civilians who commit a crime on military installations.
Yeah, that's a fair quote. Probably you could do another webinar entirely. There's such a thing as the Military Extraterritorial Jurisdiction Act, MIJA. MIJA extends the federal government's power to prosecute U.S. citizens abroad, so military contractors, folks accompanying the force. And you've seen that used from time to time by the federal government to prosecute a variety of conduct. It's not limited to some specific set of statutes, but fun acronym though. We've got time for one more, and then I'll wrap it up.
I think for the sake of time, I think that's it.
Okay. All right. Well, if you are interested in becoming a volunteer with the IHL program, there are a wide range of opportunities. We have both the IHL dissemination program, which is our outreach program, our educational program about IHL geared toward adult Americans. We have certified IHL instructors. These are volunteers, folks with or without legal training, with or without military training, who step up, they get a bit of training, and they're certified at different levels to actually go out in their own communities and conduct this outreach. The vast majority of our dissemination mission is accomplished by volunteers, just like those volunteer instructors. On the youth side, we also have a world-leading youth action campaign. So this is a 13 to age 24 focused program in which volunteers and youth volunteers work together. Those youth volunteers get trained in a subset of IHL aligned with a specific theme. This year, it's environmental protections. during armed conflict, and they go out, design, and conduct their own dissemination campaigns in the halls of their schools, in their communities, etc. Combined, there are volunteer opportunities that really vary, but they're really enriching. Last year alone, we educated and reached more than 60,000 Americans via virtual and in-person engagements. And that's not counting the more than 250,000 social media engagements that we had through venues like YouTube, Twitter, Instagram, etc. We have a great reach, but we are always looking to expand that reach and reach more Americans. And you can play an important role and make a difference in your community. And in doing so, learn more about IHL yourself and be able to better interact, better understand IHL issues that are happening out in the world, and better advocate for the respect of IHL and their enduring legacy. And with that, I want to thank each and every one of you for coming to this presentation. I hope you've learned something. Forgive me if I misstated anything for the senior military justice practitioners in the audience here. We hope to hear from you, and we hope to welcome you as a team member in the near future. You can email me at thomas.harper@redcross.org. I'll leave that up here for a second, but thanks very much, and we'll see you at our next event. Our next big event from National Headquarters is another pop culture event. We're going to be looking at IHL issues in the Avatar movies. So if you're one of the folks that contributed to the $2 billion that the new movie has made, we're going to crack that one open. We're going to crack the original Avatar open and have a fun time looking at some IHL issues on Pandora. So please reach out if you're interested in volunteer opportunities. And again, thank you so much for coming.